one of the things that I do for business owners or individuals is I help them settle their debt. Sometimes people got caught up, they got behind, they went through a rough spot. You know, it's not smooth sailing when you're on your own in business, and every month is not consistent, and sometimes people get behind and they have one creditor that's giving them a really hard time. So I work with people and businesses. Anywhere from $10,000 to hundreds of thousands of dollars of debt. I've worked out arrangements, settlements, negotiations so that people can stay out of bankruptcy. So I represent people when they're at their high points and when they're at their low points.
So with regard to the record keeping for a corporation or for a limited liability company, when I meet with clients, I always recommend that they get a binder that is used exclusively for the entity records. And with a corporation, of course, you're required to keep minutes and to prepare annual minutes every year, those written minutes, or if your bylaws allow it, it can be done by written consent. But those minutes can be kept in that binder, along with your articles of incorporation and any other important documents pertaining to the entity. But I recommend it for LLCs also, that clients keep this binder and keep any highly important relevant documents in there so that A, their corporate records or entity records are all together, and B, they're tracking the progress of the business. So for example, if you enter into a loan agreement, if you sign a lease, make a copy of that document, put it into your binder so those documents, those records are all together. And it becomes particularly important in case of litigation. I litigated commercial cases for about 20 years, and whenever we sued an entity, we always asked for their corporate records. That was the first thing we asked for. We wanted to see if they were maintaining corporate formalities and acting like a corporation or an LLC, or were in fact operating as a sham entity, is what we call it, so that we could pierce the corporate veil. So it's very important, whether or not you're a corporation or an LLC, to maintain a corporate record book. Another factor that's critical in protecting owners from personal liability is to maintain separate bank accounts for the entity. It's important to establish a distinction, a separate existence between the owners of the entity and the entity itself. And in order to do that, you must maintain separate bank accounts and separate financial records. And in addition to that, it's important to keep a record showing that all of the assets that are owned by the entity are separate and distinct from the owners themselves. So it's important to keep records showing that the assets are distinctly owned by the entity. So another component of protecting owners from personal liability is to ensure that they are holding themselves out to the public as an entity and not as a sole proprietorship. So what I mean by that is the entity, the corporation, or the LLC's records, invoices, statements, emails should all identify the organization as a corporation or an LLC, whatever the case may be. And then it's important for the owners to hold themselves out as a person who is working on behalf of that entity. They're not operating or signing a contract in their individual capacity, but they are actually there signing a lease or a bank loan or negotiating a contract or entering into an agreement with a vendor, all on behalf of the entity. So, for example, your emails should indicate, if you're an owner, you should identify your name, your title with the entity, and the full name of the business, the full legal name of the business. So for me, for example, I identify myself as Leigh Moss, Managing Member, Moss Law PLC.
On every email?
On every email, and every contract, yes.